But speaking of diminishing our civil liberties, I was watching Hayes last night to the extent that I could. I didn't want to have the TV on and have Mila see what's going on. And so I was watching it on my computer and, But at one point he had on I believe it was a former FBI agent, who was going through the process of how they would deal with a suspect if they found one. And in the course of describing the process, he said they would probably waive or not Mirandize the guy. And I think Hayes commented on it, but it was brief. And again, I missed a lot of this. But this is very important because apparently, according to Justin Elliott in Salon back in March 24th of 2011, the Wall Street Journal had reported that the Obama administration had created a new interrogation policy in which investigators may unilaterally waive the Miranda warning if they think it's necessary to get timely intelligence from a terrorism suspect. Now, understand, folks, this is different than what the Supreme Court has found in recognizing a public safety exception. There is a public safety exception that the Supreme Court has found in terms of Mirandizing a suspect. The proverbial ticking time bomb, or the handgun that they threw on the ground as they were being chased so that it doesn't end up in somebody else's hands. This is not that. According to the Wall Street Journal, it was reported in January the Justice Department had created a new but secret policy on Miranda. That rule, named after a 1966 Supreme Court decision, this is Miranda rule, holds that information from an interrogation is inadmissible in court unless the criminal suspect has been informed of his right to remain silent and to a lawyer. Evan Perez in the Wall Street Journal got his hands on Obama's new policy. A Federal Bureau investigation memorandum reviewed by the Wall Street Journal says the policy applies to exceptional cases where investigators, quote, conclude that continued unwarned interrogation is necessary to collect valuable and timely intelligence not related to any immediate threat. Such action would need prior approval from FBI supervisors and Justice Department lawyers. Now, according to this former FBI agent, he did not. That was not part of the process. So we don't know how this has evolved. Now, there is some discrepancy because the Wall Street Journal report said that what would be unchanged is the fact that any statements suspects give during such pre-Miranda questioning wouldn't be admissible in court. That's the situation now. But there clearly has been some change in policy under the Obama administration in terms of Mirandizing suspects that is more or less secret that we don't know about. So we do see a diminishment of our civil rights following these things. But that does not mean that these acts are perpetrated by the government for that purpose. That's ludicrous. And to claim so, all it does is make it easier for the government to diminish those civil liberties because it marginalizes any dissent about them.